What's up, guys? Every time I do that, I take a huge hit off my pen and then I try and talk. And look what happens. What's up, everybody? I hope you are doing well today. Hi, Shane. Thank you so much for your comment earlier on one of those videos. I loved seeing that. I hope everybody is doing well today. We have a lot of fun stuff to go over, so much so that I have notes. Okay. So, first things first, if you're new here, I need you to clock in for your shift. You do that by hitting the like button and letting me know what you had for dinner today. If you didn't like what you had for dinner, go ahead and tell me what you wish you had for dinner instead. I love to read what you guys are eating and see all that good stuff. Oh, and who do we have in the chat today? We have my friend Monica C, My Crazy Life, Sashina, Tanya Roach, Daylight Disinfectant, Becky New, hi, Avs and Broncos fan, Amy, Shane, who says he's coming. You're here now. Lawrence Browning, Lisa B, MB, all my people are here. I hope you are all doing well today. We have got some abs. Hi, Steffi B. Listen, we've got some really good court to watch today. Um, I'm going to start with what I titled the video, which is the civilian warrant application. Okay. Ooh, Daylight had a turkey breast salad with blue cheese dressing. That sounds delicious. Um, so, like I said, we're going to start the video today with the video that I titled it, which is civilian warrant applications. Another good reminder, med check, med check, med check. What that means is if you take meds, go ahead and think about that. Do you need to take them? What's going on? Just get in touch with your medicine cabinet. If you don't, come tell us about that. I'd love to hear. Mark Demeline has had mushy taters, prime rib, mixed veggies, citrus rush for dessert. That sounds yummy. Trish is here. 16 more days until jury duty. I am so impressed that Trish got on jury duty. I have a theory that if they asked a question and found out that we watch as much court as we do, most lawyers would not want us on a jury. Even though we may actually be good at it, they just wouldn't. Okay. So we are going to start out with the civilian warrant application. It is a bit of a slow day down in DeKalb County, so we'll start with that. Thank you, Mikey. There's Credence and Mikey. Oh, okay, there's Nana yelling. Nana yelling. So I actually earlier today saw the Thurston clip and I saw that you guys had put it together so nicely. I literally made a video saying, go check out Credence and Mikey's video of this because it will be perfect. So I'm going to link that at one point because I think you have it all put together, which was perfect. If you guys are new here, Credence and Mikey, OG YouTube daddies, and good friends of mine. So I tend to hang out there during the day, except today I was trying to work hard. And in doing so, while I was mining for court gold, I came across a few things. So I've said enough. What we'll do is we will start with the civilian warrant hearings. These are hearings that are put up and then taken down and is like, you get what you get. So don't get upset, as a kid, as a mom would say to kids. Um, Yeah, absolutely, Georgia Peach. That's the only way you can do it, by supporting each other. So I'm super thankful and for the path that has been carved before me for YouTube Daddy. Okay, let's get going. We'll get it started. I don't know if I'm going to cook yet or not. Haven't decided, but we'll see. Mark Demeline, thank you so much. He's sending through lovely, lovely super chats. Thank you.
probable cause was present, which is what essentially allows us to issue an arrest warrant.
So I did the audio or the speed on this one. I can't remember. You'll have to tell me. I love y'all, but you know I can't hear the difference in the speed very well. So that's your guys's, you have to help me on that. Oh, Daylight, thank you so much. You guys are awesome with your super chats and your support. It is really, really, really awesome to be part of this community. Oh, that hurt a little bit. Oh, that's sort of cute. Um, you know I love you guys and I appreciate all your support. Shane, thank you so much. Subs. We are coming up to the 2K club as well, guys, so please keep that in mind. I have relapsed on Coca-Cola and I'm okay with it. Okay? This is just the way it's going to be. I think it brings out the best in me. Anyways, so first I want you to notice something. I'm going to go ahead and pull my self off the screen here so you can go ahead and see what I'm talking about. There's Shane. Thank you, Shane. Oh my God, actually, I really like this. I love it. You guys are great. Okay, Judge Davis. It's funny because there's two Judge Davises in DeKalb County, Georgia. Georgia. You know what? Isn't Coca-Cola from Georgia? And Georgia is a bit of a lifeblood for us court YouTubers. So what we're going to first notice here is there's two of him. Here, I'll turn up for what? Okay. There's two of him and the judge doesn't like it to begin with. So let's get going. This I recorded in two different parts. Oh, I was like, why did I do that? I did that so that I could schedule the live, and you can't do that while recording. So let's get going. We'll do part one, then we'll do part two. And you're not seeing double. That is the same gentleman there logged into Zoom twice.
And whether or not one should be issued against the respondent. I'll be talking about two types of people today, generally the applicant and the respondent, okay? The applicant's the one that made a complaint to the court, and they would have very well have heard their complaint by one of my fellow magistrate court judges. Those judges would have heard and seen whether or not it met the certain criteria for us to even hear, meaning that it's not a felony, meaning that the allegation is not made against someone who is a state employee or as acting as a state actor during the allegation of the criminal act. That the warrant is not seeking merely some type of a civil type relief, because I want to remind everyone here that the court can only really do two things. They can issue an arrest warrant and issue the special conditions associated with that arrest warrant, if applicable. But we cannot make someone give them any money. We cannot make someone give a child back in certain situations either. We can issue arrest warrants and we can issue special conditions associated with that. All right? That is the relief that you are essentially limited to and that is available to you in these particular matters. All right? Once that's been identified, again, you have now been set for a hearing. And again, my job to determine whether or not there's probable cause for an arrest warrant to issue. How are we going to find out whether or not there's probable cause? Well, after I call the calendar and I confirm that appropriate notice has been sent to the respondent, and if the respondent has failed to respond after giving or receiving rather appropriate notice and service, then we very well may be able to hear the matter ex parte. And what that just means is out of the presence of the other party. Okay? Now, if the respondent is here, all right, and then what I will do is give an opportunity for both parties to present their matter. And what we'll essentially be doing is I'll give each person at the start of the matter about 3 minutes to tell a little bit of background about what the allegations are after I talk about what the actual application and crime that is alleged to have occurred. And then I'll give the respondent an opportunity to give their 3-minute background statement. And then I'll allow folks to introduce any evidence or witness testimony that they may have, either in support of the case or any defense that they have against this particular criminal warrant application. And then at the conclusion of any evidence, I'll allow the folks to be able to make a closing remarks about whether or not a criminal warrant should issue or whether or not it shouldn't issue, and then I'll make my decision. Now, a couple of things can occur. In the event that I find no probable cause, that'll be it. The case will be dismissed, and that'll be the conclusion of that warrant application. In the event that I find that there are probable cause for not only the warrant that has been issued, but I can also find probable cause for crimes that very well have been made by the applicant. And so I'm looking here to see whether or not there's probable cause on either side for an arrest warrant to issue. But in the event that I do find that there is probable cause, I am going to do several things. First, I'm going to set a bond for this individual. In many of these cases, there is no immediate harm that is taking place, meaning that someone's immediate arrest isn't necessary, particularly because some of these cases are dealing with allegations that have happened sometimes even a year ago, 6 months ago, and sometimes the immediacy of the immediate need for an arrest warrant to issue isn't there. And so what that means, though, is that I'm going to give an opportunity within a reasonable amount of time for that respondent, which then would now become a defendant, to turn themselves in. I usually give 7 days, no more than 10 days, because I don't want a person losing their job in the event that this is merely as far as it goes, okay? But in addition to, I will issue a bond as a UJR, okay? And that just stands for an unsecured judicial release. And what that means is that the person who has...
We were talking about this just the other day, what an UJR was from the jail. Unsecured judicial release. Hey, I love it when I'm right.
An arrest warrant issued against them, after they go and turn themselves in, they will be able to be released without having to put up any finances as far as bond is concerned. All right. So essentially, it's on your own recognizance. All right. In addition to, in the event that that the crime alleged is associated with any type of violence or against another person where they need to stay away, I may issue special conditions, such as a stay away, which means that you can't be around the person, you can't call them, you can't contact them online, things of that nature. If you do, you could be in violation of that special condition, and actually your bond could be waived, and you could very well still spend your time in jail until either you have either new hearing or a new bond is set. All right. In addition to, I might set other special conditions such as no violent contact, or you may have to relieve yourself of any weapons, things of that nature. So just be cognizant that if I do issue an arrest warrant, there may be more than just turning yourself in, but we will make sure that we give you that clear information if and when it's appropriate. All right. And lastly, in the event that I do not, if I find that nobody's here, meaning that the applicant is not here, the case would be dismissed against the respondent. Okay, so don't worry about that. If the applicant does not care to be present, then the case would be dismissed. All right, I'm going to call the calendar. When I call your name, I'm just going to ask that you identify yourself. And when you identify yourself, please let me know if you have any evidence or any witnesses with you. All right, bear with me.
So sometimes this calendar goes super long, sometimes it goes quick. This is going to be a quicker calendar. Very few people on this call.
2 seconds, I apologize. All right, position 1, I have got the respondent as Shawana Arnold. Shawana Arnold. Do we have a Shawana Arnold? Okay, no Shawana Arnold. How about a Angela Farley?
Yes, I'm here.
All right, Miss Farley, do you have any witnesses or evidence?
No, I don't have no witness. I had sent my evidence in, but I still have my phone right here. It still plays all the recordings and everything right here.
Now I'm going to tell you, I cannot look at those recordings on your phone. They have to be emailed to the court.
I did.
Okay, then we'll see about notice here, and I've got you down. I've got you present. Hold tight. All right, position 2, I am looking for respondent Millicent Mauricio.
I'm here.
All right, do you have any evidence or witnesses?
I emailed my evidence in.
Okay.
So the magistrate that email?
Yep, I'll check and confirm, but I believe he may have received it. Okay, so hold tight. How about I'm looking for a applicant of Ian Stewart. Ian Stewart. I think I've got you down, but Mr. Stewart, let me tell you, before we get started with you guys,
I think it's cute that he just pronounced Ian. I've never heard anybody do that before. Sort of like Hugo. Sometimes I just think of Judge Dismissal Dan saying Hugo.
let me remind you that you cannot be on 2 different devices. You can be on 1 device. I know some people like to have backup devices, but it tends to be a problem. And you end up taking up squares on the screen. So if you've got 1 device and it's good, let's just keep that 1 device.
Judge, are you worried about squares on the screen? Are you worried about me taking one up? I'm sorry.
I just need to make sure I can hear you, Mr. Stewart, because you've yet to respond to me. Can you hear me? I'll have to move along, and we'll have to see if we can hear you in order for us to proceed. Finally, position 3, that case number PP-055232. I'm looking for Bradley Ship. No appearance. And then I'm looking for Christopher Reed. All right, no appearance. All right, so that case will be dismissed for want of prosecution. All right, so folks, we only have 3 cases on the calendar this evening, so this is what we're going to do. Miss Arnold, give me 1 second to see about making sure that notice was sufficiently made to the respondent. Let me ask you here, if you can take yourself off mute. Is this your first time to the court being called to the calendar on this matter, or?
This is my first time.
It's your first time.
It was like a domestic with the baby father. He was my ex.
Hold on, before we get into all them details. I got to make sure everything else is good. Get hold tight.
Okay.
All right.
I think he's Judge Impatient. He always tries to set time limits. He's like, I'm going to give you 3 minutes, and then he never sticks with it.
Let me get you under oath, Miss Farley. You swear or affirm to tell the truth, the whole truth, under penalty and perjury of the law?
Yes.
All right, ma'am. Now, I see that you have an allegation against Miss Arnold here. Let's see, it's against. I see you don't have a date of birth. Do you have a date of birth for this person?
2/17/85.
And how do you know that?
I heard from someone gave me her birthday.
Okay.
And really, after that, I looked on the social media, how she was trying to get in contact with me, and it pulled up her name and her birthday on it. It said February 17, 1985.
Okay. You didn't put that on your application, or your on your. Yeah.
I thought I did. I was so frustrated, Judge, trying to put it out.
I get it. You might be, but I got to make sure everything else is good. So let me ask you this too: how'd you get her address?
When I put Google in, when search her name, it gave me the address.
That's not going to be sufficient for us to satisfy, especially since she's not here. Did you make a police report from this incident?
I sent all that in.
Yeah, I don't see the police. Let me see if I see the police. They may have sent it to me later. Hold on.
I sent the police report, everything.
Hold on. It might be on the report, which might be helpful. Hold tight. Here it goes. Hold tight.
I thought I did. The sound might be a bit low for this one. I don't know why.
Hold on
I
for a second.
tried.
I'm gonna read this report. Okay, hold tight. Who's Joshua Knight, Miss Farley?
That's her kid's father who I was dating.
Yeah, but this says nothing about Miss Shawanda Arnold in here. You don't even have her name on the report.
It's supposed to be 2 reports. I sent but 2 reports in.
Okay, hold on. Maybe I'm missing a report. Clark, do we have a second report?
I just said it to myself. I only saw 1 report. I can double check again if she said she sent 2.
Okay. Did you send us 2 reports?
Yes. I can go back in my email, but I'm on the phone.
I understand. Let's see if we can find them. I just need to cross-reference the information that you've provided here to confirm that it's the same on the report. Because generally looking things up through Google, we don't know whether or not those are the most consistent addresses for folks. You understand? So we don't get noticed. See, the service ain't like service when you file a regular complaint against somebody. You got to get a process server. Ain't no sheriff went out to go serve this lady. We send a regular mail notice to this person's best address and known address. So if we're going to make an allegation that this woman committed a crime and gets arrested, we want to make sure that she's gotten proper notice so she can defend herself. That's all.
Yeah, I understand.
I know, but I'm a human being. I know the frustration. I know I can see it on your face and hear it, but I'm telling you the reason why we do what we do.
I
They
understand.
could just so easily, and it happens all the time, they could just so easily make a warrant against you, say the same thing, send it to an address that you ain't really at, and be like, Your Honor, Miss Farley is a this, that, and a so-and-so.
I understand. Done had it done.
Yeah. But we want to find this because I do see the original one that you're referencing. But I want to make sure that we have it because the date of birth is not on the warrant. And you have to understand that if we were to issue an arrest warrant and we don't have a good date of birth, even though you're telling me it, we don't have anything to cross-reference and confirm that. If they do issue one, they can't even arrest her because it ain't the person that you're looking for.
Okay, so there's where I cut it. Give me a second and I'll grab the next one. Yes, I was on a bit of a lobster kick last night for some reason. So weird. Oh, I know weird things. Okay, don't worry. So, and also the second hearing I have for us today, I think you guys are really gonna like. These lawyers get so snippy at each other. Love it. New judge, so many good things. Okay, this is the one I think I sped up a little bit, but let's see.
I ain't saying that. I ain't saying that.
Yeah.
I'm just here. I'm defending
Hold
myself.
tight. While you do that, let me just confirm if Mr. Stewart can respond yet. Mr. Stewart, can you talk? I can't hear you.
So we can see that previous kitchen went 0.1, 1.5 there, which means to counter that, I need to go 0.75.
Still can't hear you, sir. And it's crazy because you're on 2 devices. One of them should work.
Are you hearing me now?
I can't hear you. Can you turn off one of your devices?
I turned it off.
No,
I turned it off already.
It's still on my, you need to hang, there you go. You weren't hung up. Okay, I got you down. Let me ask you, now that I've got you here, do you have any Do you have any witnesses or evidence?
No, sir.
You have no witnesses or evidence?
No, sir.
Okay. All right. Hold tight. We'll get to your case shortly. You and Miss Melissa, excuse me, I forget how to pronounce your last name. Forgive me that. But nonetheless, we will get to you guys' cases shortly here. All right. And clerk, did you see any other police report?
Yes, Judge. I think I sent it to you. Just give me a moment.
All right, give me 1 second. Hold on 1 second, Miss Farley.
I was trying to put it up on my email to resend it again.
No worries, we're gonna check it out shortly. Hold on.
Oh, Larry Beaver makes an appearance in this clip.
It's moving a little slow. We're gonna get it right. There it goes. All right, so this is, when you're looking at this report, I'm gonna share it with you. Hold tight. Bear with me, Miss Farley. The internet is a little slow, okay?
Okay. I was at work. They understand though. I told them.
Okay, I'm glad they're patient. All right, I'm gonna share you the police report, okay? Hold on 1 second. Oops. All right, Ms. Farley, can you see this report here? Oh. Can you unmute yourself?
Yes, I see it.
All right, so this is the thing. This is your information. Let me scroll up from that. Hold on. It's just moving so slow. You see this? Well, as soon as it loads, I apologize. See this box? You see I don't have none of her information in it? You see how I can't have an incomplete warrant application and a complete police report where it doesn't have any of her information confirming where she lives or her date of birth, okay?
But they didn't ask me. They didn't ask me that though. I would have gave them the same address I gave on the warrant.
I know. I'm not disagreeing. I'm just saying, if you looking at what I'm looking at, which is what I'm looking at, there's no information on the lady. And if I said Miss Shawana Arnold, you arrested, it could be multiple Shawanas.
What do I need to do, Judge? Because I know that
you need to go to the police if this is what you want to do, and you need to ask for them to have the report completed with her information so that we can at least get her a proper notice. But I can't issue an arrest warrant and I don't have any clear information on who this woman is, other than what you tell me.
Okay, I can do what you told me.
Okay, well, and listen, this is your application. I'm not telling you that. I'm not dismissing it. So let me first be clear. I'm not dismissing it. But I'm merely indicating to you that if you want the court to do something to this degree, which is an issue an arrest warrant, especially when the person isn't present, we've got to make sure that we have all the boxes checked so that we protect people's rights. And that is making sure that we at least have their correct information. And usually that's good with a police report because they'll usually run the most known their address listed, and then at least the date of birth so we can confirm who this person is, okay? And so if we can get that information, we can get you rescheduled. But until then, we'll take you off the calendar and we'll wait for you to give us that information, all right?
Okay, I'm about to do that now.
All right. Well, listen, you do that, but you do that in a safe area, and you have a great night.
I am. Thank you.
Thank you, Ms. Farmer. All right. I'm now going to return back to position 2 here. Bear with me.
This will now be our main event for the civilian warrant application hearing. The applicant is the gentleman on the top right. The respondent is the woman on the top left. Look at Val subscribing. Oh, I love you all. but we have about 20-ish, 20 something minutes of this, and then we have our lawyer fight that I don't think I'll call it a fight. It's a spat, and there are some fun numbers going on. So, let's continue. If you're just getting here, make sure that you've clocked in for your shift and hit that like button or dislike button, really, whichever you prefer. And let us know what you're having for dinner, what you are drinking, smoking, toking, having fun, all that kind of stuff. I wouldn't even call this the main event. This is just the title event because I don't like to do clickbaity things. So this is a civilian warrant application. That's what I said we would watch. That's what we will watch. Also, yes, med check, med check, med check. That means take your meds, folks. Take your meds. Val is here from Florida, just relaxing. Sashina's having coconut rum and Diet Coke. Courtney is having grilled walleye and cherry punch. Hi, Cachette. Hi, Lucy. My friends, my friends, my friends. Hi, Richard Harrison. I'm so glad you are all here. What does this say? My husband took some pics of a Cooper's Hawk. Oh, geez. I didn't read the first sentence, MB. I read the middle one. I thought you guys were eating hawk and dove. I was getting a little concerned there. Great punch, but you don't drink it, says Bandon. That sounds like my kind of punch. Just like my kind of favorite kind of wedding cake, if you know what I mean.
And that's going to be Mr. Stewart against Miss Marshall. If you guys can both unmute for me. All right. So, as I indicated to you guys earlier, I'll be conducting essentially a probable cause hearing. It's somewhat similar. It may feel like a short bench trial, but it is not. There are a lot of, I wouldn't say limitations, but more so we allow a little bit more information to come in that we would normally in a trial. But the purpose of this is just to make sure whether or not the allegations that have been made sufficiently meet the appropriate legal threshold to issue an arrest warrant. If they don't, then there won't be an arrest warrant. If they do, then there very well may be. So, Mr. Stewart, if you can, unmute yourself for me, please. And I just want to also remind you, I do see that you're in a vehicle. I know things sometimes happen. It can get late. Just don't start driving on me, all right?
Okay.
All right. So if I can have both you, Mr. Stewart, as well as Ms. Marshall to raise their right hand so I can get you guys both under oath. Do you swear or affirm to tell the truth, the whole truth, under penalty and perjury of the law?
I swear.
Yes, sir.
All right, you do. You guys can put your hands down. So this is what we'll do, and I'll go back over again how we're going to proceed. First, I'm going to give each of you 3 minutes to give me a brief background, specifically regarding this allegation. This is the allegation that we're here on. When you're aiming a gun or pistol.
Guys, I think we have hit regular speed. Please tell me, do you not think he's at 0.75 right now? He usually, just tell me. If I'm wrong, but tell me. Also, Cachette, thank you so much. Do you see me? Oh, yes. Oh, yeah. Thank you.
Pistol at another, as well as criminal trespass damage less than 500. These allegations were to have occurred on April 25th, 2023, at 2 different times in the day, one at midnight and the other at 5:30 p.m. Let's see, I do have all of the appropriate here information. So when I ask you guys to give background, I'm specifically talking about that date of incident. I understand there may be some additional time that you guys want to talk about other things, but I'm specifically dealing with this particular incident date. I know a lot of folks like to tell me about whether or not there are dealings of years or months in the past. Some of that may be relevant, but most of it is not, because we're dealing with predominantly these 2 allegations, okay, that occurred on the 25th of April. And then after you guys give your 3-minute openings, I'll let you guys introduce any evidence that you have. I know Mr. Stewart says he didn't have any. If Ms. Marshall chooses to introduce any evidence, she may choose to do so. And I want to remind you, Ms. Marshall, if you choose to be represented by counsel, that is your a right. If you choose not to be and proceed on your own accord, that is fine as well. Both are fine. It is just up to you. But nonetheless, if we proceed today, you'll be given an opportunity to introduce any evidence. Neither of you have introduced any witnesses, and I will allow you guys to then cross-examine each other. Sometimes that's productive, sometimes it is not. If it gets out of hand, I will go ahead and stop you guys. But the goal, obviously, is to elicit any information that would be able to allow the court to determine whether or not probable cause for a crime has actually been met. And then at the conclusion of those cross-examinations here, I will allow you guys to give another brief statement or summary of why either the arrest warrant should be issued or not, and then we'll conclude and I'll make a determination, all right? All right, so I've got you guys under oath. So Mr. Stewart, it is now 6:39. I'm going to essentially say it's 6:40. Okay, so I'm going to give you till 6:43 to give me background on your, on the...
So this is what I'm saying. He plays hardball. I'm going to give you till 6:43. I've never heard him cut anybody off, you know? You guys are so sweet. You make my day very, very much every day, really. And I'm so glad that I can hang out with y'all in the evenings, and that y'all like court, because you know how everybody in our lives thinks we're a little crazy for that. So it's nice to have friends that like the same stuff. We have less than 20 minutes to the end of this hearing. And I'm telling you that only because I think Judge Davis realized, shoot, I got the night off after this is over with. And I think he realized early on he wanted to finish it quick. So we have just under 20 minutes of this hearing left, and then we will go on to these bickering lawyers that I found, which I'm just excited about.
Incident of on April 25th for the point of your gun or pistol and criminal damage to property 500.
Well, Your Honor, I came in from work at about 3:45 because I left work at 3:30. So I came home about 3:45. I saw my clothes, everything in a car outside the driveway. So I came out my truck. I went to the door. She was sitting in her car, and I didn't realize that her car was parked there because when I came down, nobody wasn't there. So when I came out the vehicle now, I saw her truck. So I went up to the driveway, take my key out, trying to open the door. The night latch was on the door. So she turned to me and she told me all kind of bad words. Take your clot out, Warrant, not sit clot and come out. See your things in the car there. Take it and leave. So I take my phone out.
I'm not trying to be rude. I do not understand. And I understand Scottish accents. I know they're speaking English with a Jamaican accent or patois, but I can't follow it so easily.
And I started to call the police. So when I started to call the police now, she's driving away because the cul-de-sac is a dead end. So she's driving around to go up the street. So same time she stopped, she pulled out her gun and said, get the F out my driveway and take your clothes and go about your business. So I'm there calling the police saying we're not paying her no mind. So she drove away. So I went across the street now and sit down and called the police. So when the police came, I told him. So I said I would like to file a report because she pulled a gun at me and drove away. So he said, you have witness? I said, no, officer, I don't have no witness. Nobody ain't on the road. It's 5 o'clock in the day. The sun is hot. Nobody ain't around. It's just me and her. So it's my word against her word when we go in front of the judge.
I told you guys I had notes, and I want to read you my notes because I don't think they'll spoil anything. I think they'll just maybe give you a little bit of insight into my thoughts while listening to this hearing the first time. The first note I have is he canceled my insurance. Then I don't know if I can say this. I unalived my husband. He passed me across the lawn, right and left and right. Brand new door, question mark. Jamaican accent. Camera plane. He took his phone out. That's all I got. Those don't even make sense to me now, but maybe they will later.
Him say, okay, if I don't have no witness, I don't think it's going to be possible. I say, I don't mind. I will talk to the judge about that. I will tell that to the judge. So I went and I called the police. When the police came now, he started to take the statement and everything from me. So he said to me, I must lick the door off, beat it down, and go in. I said, officer, I can't do that. He said, I give you permission. She can't put you out like that. She have to have a warrant to get you out. She have to go through the courts. I said, okay, Your Honor. Okay, sir. All right, I get something out my truck, and I tried to beat the door down, and it couldn't open. So I put it back in the truck. He said, you have a number? The police said, you have a number? I said, yes, I have a number, but she's not going to answer you. So he said, give me the number. So I gave him the number, and when I gave him the number, I called her, and she didn't answer. So he said to me, she don't answer. I said, I told you, she's not going to answer you. So I'm talking to the police, so when I look up the street, and I saw her coming down. I said, officer, see her, you're coming. So she come down, the officer approach her and tell her that she pulled a gun at me. She said, no, it's lie, it's lie, it's lie. So the officer said, open the door and let him in. So she tell her daughter to open the door because her daughter was upstairs in her room. She don't know what's going on. So she came down, she opened the door. Her mother called her to open the door. She opened the door. I went in, I put back all my stuff inside and take them out the bag and put them back in the drawer where they're supposed to be. So when I put them back where they're supposed to be and everything now, she drove away. The officer left. She came back with some powder and sprinkled it in the room and kick over my radio, my sound system, kick it over, break it up. So I went for my phone again and I called the police again. And the police came back. So when the police came back again, she jumped in her car and she leave. She gone again. So I said, officer, she left and she break up my stuff. So I said, okay, all right, I'm going to put the notes down. He said, how much for the radio? I said, $200. So I showed it to him. And he said, okay, all right. When they file a report, it's going to be on one. I said, okay, no problem. So I said, officer, don't leave her. She's coming back again because she's crazy. She's coming back, officer, don't leave. He said, no, he's not going to leave. You're going to wait here. So her daughter told her that the police is outside, so she's not supposed to come back. So she stayed out until about 12 o'clock. When the officer leaves, she come back in the house. When she come back in the house, she going all crazy again. So I called the police. Again, in the midnight, I called the police. The police came back again. So the police turned to me and said, why are you guys acting like a child? You know how many things going on in Atlanta? People have been dying in Atlanta and you guys going on like your kids? I said, officer, it's not me. I don't want to get myself in trouble. So the law is there for me to call. So I'm calling the law. Right? You wrong with?
I think I got it. I'm going to give an opportunity for Ms. Marshall to respond. I'm going to have some additional questions for you guys as well. But go ahead, Ms. Marshall. Go ahead.
Okay, officer. Judge. So, I got a voice note. He accidentally sent a voice note to my phone speaking a lot of derogatory stuff about me, about how I killed my husband and all kind of derogatory, and he didn't like me, he's staying, whatever. So that's how come I pack his clothes and put them in my son's car outside. So I waited for him because I know he come, like that part was right, like about 3:45, and I waited for him. So he passed me. He passed me. Soon as he turned around and parked, and he walked across the lawn and he came out his car with his phone in his hand, and he walked across the lawn. And I said to him, because my car was facing down and my gate would be on my driver's side, which would be my left side. I turned to him and I said, no need to go in the house. Everything for you is in the car. And I go around the cul-de-sac and I drive away. Right? I have a camera, blink. So I see everything. So I was by Publix. Publix for me is like 2 minutes away. So I sat there in Publix Plaza because I know he was going, oh yeah, and he took his phone out. So in that, to me, if you have your phone in your hand and someone point a gun at you, what you gonna do? The first thing you're gonna video them, right? Because he have his phone in his hand. So he's saying I point a gun at him, lying at me. Okay, so I sat and I watched the ring and I saw the police come and I saw him licking off the door with the object he had. And so I turned, at that point, I said, oh wow, okay, I don't want him lick my door off because I just put my door on, my brand new door. So what I did was I turned around and I came home. Nobody called my phone. When I got home, he said, officer, there she go. The police asked me and I stopped and he asked me, he said to me, he pointed a gun at you. I said, officer, no, I wouldn't do that. First of all, I have license, CNA license, I'm a salon owner. I have all them Secretary of State, all them stuff. I'm not crazy because he's not worth it. So I wouldn't do that. And I have my kids and grandkids. So he's just trying to send me to jail for whatever reason. He canceled my car insurance. This is what started up the whole thing. And when I asked him about it, he cursed me out and told me he was just waiting for the police to lock me up. And I'm lucky he went to his friend and his friend said, no, you can't do that. So that's how come he come and didn't even tell my daughter that he canceled the insurance on my car and let me and my children drive to Florida without an insurance on my vehicle. He did that, all of that. So I don't know why he's trying for me to go to jail. And his stuff that he accused me, Your Honor, of stealing, there's all on the video that I submit to you that he find his ring, social security, passport, and bracelets, all his jewelry is in the bag that he was supposed to pick up on the 18th when we have the court on the 18th, and the judge give him till the 19th to pick up the stuff, and he didn't come. So instead of he come and get his belongings and find his stuff in his belongings, because I was mad and I packed everything. Everything was thrown in. Everything was in the bags. And the police officer was there and saw that he got, everything. And I want to get him for defamation of character too, because the stuff he tell about me.
I got it.
So he has everything.
Well, let me ask you this question real quick, and I'm going to ask first, Mr. Stewart. Mr. Stewart, did you submit the police report to the court? Because I don't see a police report.
Me?
No. I'm talking to Mr. Stewart.
Oh, okay. Because I didn't. He called.
No, Mr. Bishop. Did you get a police report?
Yes, I gave the police the report. Yeah.
To the court?
No, they made the statement and everything already, and I went and collect the paper.
Okay, so you have a police report. Did you send it to the clerk's office?
No, I didn't send it to the clerk's office.
Let me just confirm. Clerk, were you able to find a police report for this particular incident?
I don't think so, Judge, but to be on the safe side, I'm checking.
Okay, they're going to check. Miss Monroe, what evidence did you, because I didn't see any evidence submitted. What evidence did you submit?
I submit when he come and pick up his document, he come and pick up his belongings.
I do like this judge. I've seen him quite a bit. I have a few videos of him on my channel, and I think I've done a few of his stuff live. I love how I seriously think it's so cute. He always tries to give people like time limits and he never follows them. Um, I think he's really good at sussing out certain situations. He reminds me quite a bit of Dismissal Dan. He is really, again, a lot of the judges that I think I personally enjoy are ones that are dealing with people as opposed to dealing with lawyers. And this is again a case where he's dealing with applicants and respondents, not necessarily lawyers. And so there's this difference of style and presentation from a judge when they're not dealing with colleagues. So, oh, Donna, thank you so much. Oh, I might be perfectly placed for this. Let's hope that happens.
Submit the thing. I send it to magistrate, the cab, something. The number when I call and they send me to.
But do you have any video of that date in question? Not when he went to go pick up his stuff, but from that evening.
No, that evening when he said I point gun at him.
The 25th. Do you have any video?
I didn't need a video because I tell him what I was telling him and I left.
I got it. Let me ask Mr. Stewart, what evidence do you have to support the damage to property as well as the pointing the pistol?
The police took the picture of damaging my stereo, but right now, Your Honor, the only thing I'm worried about is my passport and my social security that she put back, because they was in an envelope. My social security, my passport, my birth paper, my nationality, everything was in one envelope, Your Honor. It was in her care. So that envelope should be in the bag with my possession of.
So, folks, let me clarify, and let me remind you what I can do and what I can't do. I can't make your passport appear. I can't make your social. Oh, Miss Marshall, hold tight.
Sorry.
I can't make any of that happen. I can issue an arrest warrant against Miss Marshall or not. And I'm just trying to figure out, because you've taken the court's time, and I'm happy that you guys have found this to be important because we want to make sure that we can resolve those matters. But I want to remind you, this is not a court to resolve a lover's dispute or quarrel. If you're going to come here and you say that you got evidence to support it because there was no arrest actually issued the first time, what the court really sometimes has an issue with grappling is where you're saying one thing, she's saying another thing, and you guys are saying he said, she said. And there's no probable cause there. Now, granted, I can say I believe you more than her, but I don't have any evidence either way. And so I'm saying, what if you guys have nothing, you don't have pictures of the damage, you don't have pictures, anybody supporting this, you pointed a pistol, why should I believe you, Mr. Stewart, more than I should believe Miss Marshall?
Your Honor, can I speak?
No, I'm asking him a question. I apologize, but
Okay.
you make sure.
Yes, Your Honor.
Yeah.
Yeah. What are you saying, Your Honor? Pardon me.
I'm saying you don't have any evidence. Why should I believe you more than I should believe her?
Lies.
But Your Honor, remember, it's her word against mine.
Right.
Okay? Because she don't have no evidence, I don't have no evidence. Because it's me and her alone in the 5 o'clock brawling day sun hot. Nobody was there when we have no altercation. Everybody gone to work. So I don't know how she.
Let me ask you this question. Is this your wife?
Huh? Used to, not again.
Hold on. Is this your wife?
Used to, Your Honor.
What do you mean?
This is confusing. Hector, thank you for being here. What do I call dancing? I call dancing what I do in my kitchen. There's a reason I do it in my kitchen. I'm not a club and court lady. I'm a kitchen court lady. Anyways, this is weird. They are married, but they're not. The judge is like, gotta suss this out. What?
When did you guys get a divorce?
Your Honor?
When did you get a divorce?
I don't get a divorce, but it's not my wife, Your Honor. It will come up shortly, but it's not my wife.
Listen,
okay?
I don't know where you live, but until you get a divorce,
Your Honor, I'm from Jamaica, okay?
Yeah, but
I'm from Jamaica. She is from Jamaica.
Georgia, in the United States. So let me ask you this. This is your wife. You don't have a divorce. Are you legally separated?
Yes, Your Honor. Yes, Your Honor. We legally separated.
Okay, Ms. Marshall, do you have a legal document from a judge saying you're legally separated?
No, but I have a TPO for 1 year, Your Honor.
Okay, you have a TPO for 1 year.
Yes.
You guys don't live together anymore?
No, he can't contact me within 100 yards. You know the TPO, you know that.
Okay. All right. When did that TPO go into place?
The first one was on the 20. What's the come at the first, the third. Oh gosh, what was it the third? Oh, look at it.
The first, the third of what month?
It was this month was
June.
Last month.
Okay. All right, hold on, Mr. Stewart. Do you have a TPO against you regarding Miss Marshall?
Your Honor, when I tried to take the TPO out, the officer told me.
No, listen. Answer my question.
No, sir. No, sir. No,
you
sir.
Don't
no,
have
sir.
You don't have a TPO. You cannot be around Miss Marshall. Is that what you're telling me?
Yeah, I can't be around. Yeah.
Okay, so you do have a TPO.
It's May, Your Honor. May.
Okay, I got it.
May 1st. Yeah, it's he's not supposed to contact me in no way, and he did. He sent his friend to my house, and I'm not as wicked as him.
Listen, folks. In all due respect, as much as I understand the seriousness of people pointing pistols and damaging folks' property, you guys clearly have marital disputes, and this is not the appropriate forum. Now, if I had some evidence to support what you were saying, then I'd be happy to issue an arrest warrant, right? But I don't. And you've come to the court doing a he said, she said with your wife.
He can't say he said, she said. Let's go back. We'll listen to that once, and then he unfortunately just cannot get it home. And I think it's the cutest thing. And don't worry, I know what it's like. I do public speaking, YouTube. It's hard, but I'm telling you, he can't say he said, she said.
To issue an arrest warrant, right? But I don't. And you've come to the court doing a he said, she said with your wife, right? Who you just recently got a TPO against you. This just isn't the forum for that. But if you had some evidence, if you had a witness, if you had something to support, so it wouldn't be he said, she said, especially in the light of a TPO, it's very difficult for me. And well, I know it's going to be difficult enough because I'm not going to issue an arrest warrant. And so because I don't find that you've met the appropriate probable cause, regardless matter, you haven't supplied anything for me to make any type of different decision than the officer did. And he didn't make an arrest warrant either. And so you haven't given me anything additional.
But the officer has the picture, Your Honor.
But I don't have the picture. There's no picture. There's no picture attached to the police report.
Officer Talbot has it.
Okay. Why don't you have a picture of the own that she damaged of your stuff? Did you not take a picture?
Your Honor, can I speak his mind?
No.
Your Honor.
Yeah.
Okay.
Your Honor, you see, because I got back my passport and my social, that was my problem.
And let me tell you, I do not have the authority to give you or get her to give you what you claim she's taken, because I don't even have any evidence that she's taken.
No, I got it, Your Honor. I got it. I went to the police. I went to 2 police Monday on President's Day, and the passport was in the bag on the top of my clothes. And I took my clothes in from the 25th of April, and nothing was inside there.
Mr. Stewart, I'm reading from this own police report that it indicates that he didn't have insufficient evidence in order to determine that she damaged the speaker. And you don't have anything else for me as well. And you don't have any other evidence to say that she pointed the gun, and she clearly just said under oath that she did not. So I'm going to dismiss the arrest warrant. I really do hope that you guys get your marital issues resolved. But nonetheless, I do not find that the probable cause for the allegations of criminal damage to property nor pointing a pistol. And that'll be the court's order, okay?
Yes, sir. And I only want to know how to get back my passport and my social. That's all.
That'll be something else for you guys to deal with, but not with this court to control, okay?
She shed, I the shy shore. what did you guys think about that? I'm just getting our next hearing ready to go. Don't go anywhere because I think it's going to be epic. I only caught the end part of it, and then I was like, oh, we need this whole thing. So, we are going to be going. Oh man, so good. So my screen just turned off. Now it turned back on. Okay. Do 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 do. I was just thinking about it. What did I call it? Called it this. I didn't call it shit. Don't lie, Kitch. You didn't rename it as shit. You just download.
Good afternoon, everyone. This proceeding is being live streamed on YouTube consistent with the open courts provision of the Texas Constitution. If any of the parties before the court have an objection to the live stream, kindly bring up your objection to Judge Burgess once he calls your case. As a friendly reminder, only the parties in the case that is currently being heard need to have their camera and audio turned on. Everyone else, please remain with your camera and audio turned off until your case is called. With that being said, the 455th District Court is now in session. The Honorable Judge Burgess presiding.
Good afternoon.
Good afternoon, Judge Burgess. Yeah, this is a different format of video, so I bet the audio is way better, which I'm glad for. So what are we gonna do? How are we gonna do this? I'm just deciding. I'm gonna let him speak for a little bit, then we're gonna see who pops up first. The hearing I'm specifically looking for is a civil hearing. It appears to be a landlord-tenant issue, but the tenant is a lawyer. And he is making things very, very difficult. Did you, Monica? That's awesome. I managed to grab the whole thing.
The first case on the docket that was given me is cause number D1GN 19003195195, Juan Silva versus ARA Diagnostic Imaging et al. Would the attorneys please announce your appearances?
Okay, that's not it.
Background was another.
So I'm going to skip. Oh, there they are. See, it didn't even take that long. Oh my God. Look at this. Here we go. Here we go. Okay, here's the thing, guys. You know, I've had many jobs. One of them was selling high-end furniture for a furniture website. I'll tell you, the first time somebody put in an order for a couch, sight unseen, for like $25,000 on a credit card, I just about freaked out. I was like, what the But I got used to it. The expensive sheets. I've told you guys about the $1,000 sheets. Yeah. Okay. So, I want somebody to do the math here because we're going to be hearing about some expensive rent, my friends.
Okay, we're ready to proceed in the next case.
Okay, go.
Kazinart Singh, Clements versus Laurie and Kazinart Singh and Harbir Singh. If you will announce your appearances for the record.
Your Honor, Anthony Eisnagel for the defendants and the movants on the motion to quash that is before the court.
right?
And Judge, I'm Brad Clements. I'm a pro se attorney plaintiff, and there's also on the docket my motion for a remote hearing on a different matter.
Oh, pro se plaintiff attorney. You know what they always say about the lawyer who has himself for a client. He has an idiot for a client.
Okay. What day was the motion to quash filed on?
Oh my God, his name is Bradford. Oh my God, his name is Bradford. Oh, this is getting better and better every minute, you guys.
The motion to quash was filed on May 18th.
Motion to quash subpoena ducus taken for the records of Chase Bank.
That is accurate, Your Honor.
Okay, let me pull it up. And was there a response filed?
Yes, sir. It was filed on June the 1st.
Yeah, I've got it pulled up.
I believe we are going to find out that Bradford has impeccable taste and that that is, in fact, not a background. I don't know if we see pictures, but I fucking wish we did. Also, this is a pretrial motion, by the way. Just so everybody, if y'all want to run and cry about this, you're not going to get a freaking ruling because it's a pretrial motion. Oh, and I should clarify, you'll get a ruling on the
You may
motion, but
proceed.
you're not going to get a
Thank you.
ruling on the entire
Thank you, Your Honor.
case. That's what I mean to say. So let's just do a little debrief. This is a pretrial motion in a civil case where the guy in the top right, Mr. Bradford over here, has the most uncomfortable looking couch. Look at those sharp angles on the pillows behind him. And then he is suing the person who rented him an apartment, and Mr. Ice Noggle. First of all, Ice Noggle. That's a banging name, right? Mr. Ice Noggle is defending them. And they get feisty, guys. It's going to get so good.
Honor, I would tell the court that we also filed a reply on Friday, June the 9th. I don't know if that has made it its way to the computer you're looking at or not.
No, I have the one June the 1st. Let me see if I can find something on June 9th.
Hi, Evelyn. You guys, is that the corner piece of a couch that he has taken the end pieces off of? Judge is puzzled about this too. It's obviously first thing on his mind.
Judge, from what I can tell, it's not on Smart Bench yet.
Yeah, let's say I can.
That's fine, Your Honor. I can proceed without the reply being up.
Yeah. All right, you may proceed, sir.
All
And
right, thank you.
pronounce your name again for me, sir, so I can write it phonetically.
Sure. Ice Noggle.
Ice
Ice Noggle.
Noggle. Mr. Eisnagel. Okay, you may proceed.
Thank you, Your Honor. So, Your Honor, the parties here are Mr. Clements, who is both the plaintiff and a licensed attorney in the state of Texas representing himself. And then my clients, the husband and wife, last name of Singh. The parties are in this litigation because my clients rented a residential condo to Mr. Clements. That lease terminated, and at the termination of the lease, as the court knows, there's generally a return of a deposit. A dispute has arisen concerning, among other things, the return of that deposit. As the court can tell from the style, the parties to this case are Mr. Clements and my two clients, the Singhs. The Singhs, who are the defendants, are on the lease as the lessors of this condo unit. As part of the process of handling this matter, the Singhs directed Mr. Clements to make his monthly rental payments and his deposit payment to an entity they own known as CS44 LLC. It's important for the court to note in looking at the
That's super sus. And I live in a province in Canada where we are literally one of the most business friendly places. You can get a numbered company here and not tell who owns it. But that's funny.
style and in the rest of the pleadings that CS44 LLC is not a party to this litigation. As part of the discovery process, Mr. Clemens issued a subpoena ducis tecum to Chase Bank. Chase Bank is the bank in which the bank accounts of CS44 LLC are reposited. As the court may well know, there's a process under Texas law for the production of bank records. That process is found in Finance Code 59.006. 59.006 provides for two methods of subpoenaing someone's bank records. There's a method for subpoenaing the bank records of a party, and there's a method for subpoenaing the bank records of a non-party. In pursuing this subpoena, Mr. Clements used the method for a party. We have moved to quash, and it's important for the court to understand that there is real distinctions between the two different methods for subpoenaing bank records.
Say subpoenaing one more time. Why my brain's just like peening. God. Oh God. You guys are good. This is petty bull, by the way. This is going to come down to pettiness.
Methods that provide significant protections to a non-party whose bank records are being subpoenaed. And so we moved to quash the subpoena on two bases. One, that the way in which the subpoena was pursued and issued is not appropriate for a non-party, which CS44 LLC is. And number two, that even if it were appropriate, the records being sought are not relevant to this litigation and therefore not discoverable based on they will either not tend to lead to relevant information or they are in fact not relevant. Mr. Clements has responded to the motion and as best I can tell, has cited a federal district court case, a case called Albert versus Riley. Albert is spelled ALPERT. And in that case, he points to a federal judge ordering the production of records under a subpoena. And he asserts that that case shows that under certain circumstances, the records of a non-party can be subpoenaed through the party method instead of the non-party method. And we would tell the court that charitably, Mr. Clements misreads that case, because what that case stands for is the proposition that a trustee is the appropriate party to a case involving a trust. And so in the Albert versus Riley case, Mr. Riley, the trustee of several Albert trusts, he was sued by the Alberts, and there was a subpoena directed to the bank that held the trust funds. Mr. Riley asserted that those trusts were non-parties, and what the court in that Albert versus Riley case says is, no, you, Mr. Riley, are the trustee, and since you are a party to the lawsuit, and he's in the pleadings, since you are a party to the lawsuit, the party rules apply to you, not the non-party rules. That is not applicable in this case, Your Honor. CS44 LLC is not a party to this case. You can look at the style and you can see they are not a party. In the Riley case, as trustee, Mr. Riley was a party to the lawsuit, and that is why the party rules apply to him as opposed to the non-party rules applying to that bank account. Your Honor, that to the largest extent brings this matter to a close, and you should order that Mr. Clements be required to seek these records through the non-party method, and then the bank can act accordingly, and my clients can act accordingly. In addition, what Mr. Clements will do, Your Honor, is he will try to convince you that the fact that my clients own CS44 LLC somehow makes that entity a party. And I think the court is fully aware that entities serve a purpose, that you simply don't ignore entities at your whim, and that there is no basis for ignoring this entity. One of the bases he's going to assert is that he believes, without evidence, that CS44 LLC is owned by a trust that is then owned by my clients. That, Your Honor, is a red herring, because again, my clients are not the owners of these bank accounts. The owner is an entity. The entity is not a trust. The entity is an LLC. And there is simply no basis, no support in the law, certainly no support in the statute for allowing him to pursue a subpoena of this entity as if it was a party, because it is not. Secondarily, we have asserted that the records are not discoverable. And what I would point the court to, and it's in, the subpoena is attached to our motion. And in Mr. Clements' subpoena, he asks for records, bank records from October the 1st, 2021 through the present. He does not restrict those records to any financial transactions with him. He asks for all the records, number one. Number two, he asks for them over a time period during which the lease wasn't in place. That is, the lease didn't go into place until November of 2021, and it terminated in December of 2021. And so asking for records for time period before and after the lease is clearly not discoverable.
Okay, you guys, we need to be watching very carefully for Bradford. I thought I saw a flicker of a background there. Absolutely critically important to know that. Because I think it's just his chair. It's just, anyways.
he sets out in his response 5 reasons why he believes that he's entitled to these records. The first is that he wants to be able to show that his rental payments and that the deposits made were timely received. Your Honor, this is a red herring and a non-issue. Mr. Clements has already produced in this case his bank records, which show those things. And so there is no reason to subpoena the records of a non-party to show something that's already shown in this case. Secondly, he wants to know whether CS44 ever made payments to other parties. And the point which I'm now repeating redundantly is, why is that relevant? CS44 is not a party to this suit. Whether payments should have been made in this case.
Sorry, can you repeat that? You dropped. CS44 is not a party.
Whoa, first of all, who is that? Second of all, repeating redundantly sounds like a t-shirt. I'm gonna write that down. Repeating redundantly. You guys are gonna like the judge. I caught part of him and it's great. You're also, I think, going to, I know it is probably Hector, I'm sure it is the court reporter, but it's just funny to me because, well, regardless.
To this
Suit.
Thank you.
Whether payments were made in this case is only relevant to the extent that the defendants made them, not relevant with regards to whether a non-party made payments. That's not relevant in this case. Third, Your Honor, and this gets way into the weeds, there's a gentleman in this case named Mac Flegel. He, Mr. Flegel, did some work at the apartment after Mr. Clements terminated the lease.
Mr. Flegel? Really? Are we going to go with that? Flegel? Illegal Flegel? Okay, I'm going to tell you guys what I ended up knowing, is that he signed a lease. He paid a deposit, paid his rent, and there's a dispute over if he ended the lease early and if he has been in receipt of his deposit. Now, where I live in British Columbia, Canada, there are some pretty strict rules about deposit being returned. And they go somewhere along the lines of you do a walkthrough at the end with the 2 people. And at that point in time, the return of the deposit is discussed and laid out as to why you get what you get. If that doesn't happen, the landlord has like 15 days or something like that legally to return the deposit to you. And if they don't, I think there's something like triple the deposit that you get back because there's really strict rules about it. So obviously I'm not a lawyer and this is in Texas, but you're going to find out a little bit down the road of this hearing, exactly what this guy thinks he should get, etc. So let's continue. Also, I'm so happy that you're all here. Make sure you've clocked in for your shifts today in the kitchen. I think we're all going to cry when we hear how much his rental payments were.
He was paid for that work. It's part of what was deducted from the deposit. Mr. Clements asserts that he has some right to know when Mr. Flegel deposited his check. You couldn't be less relevant in this case if you tried. Fourth, he says that he wants to know if CS44, again, a non-party, paid the maids who cleaned the apartment. To which the response is, Who cares? They're not a party. It's undisputed, Your Honor, that the maids were paid, which would be the basis of the issue here. Are you charging me against my deposit for work somebody didn't do and didn't get paid for? It is undisputed they got paid. The issue is whether...
How is it undisputed?
Well, a couple of ways, Your Honor. Number one, the invoice that they issued has been subpoenaed by Mr. Clements and shows payment. And Mr. Clements not only has those documents, he subpoenaed them, he filed them with the court this morning. So he full well knows that Molly maids got paid. It's undisputed they got paid.
So why, let's just talk pragmatically.
Sure.
Why isn't he entitled? I don't know how he proved he paid.
So the judge, I love here. Lisa, I love you all. Search for Spock, thank you for the heads up. I forget sometimes I got to get these puppies up right front and center. I appreciate that so much. Molly maids got paid, and that's good because don't fucking hire people for service and not pay them. Don't do that. You rich people on the screen. Not me, obviously. I've cleaned houses for money before. Let me tell you something, okay? You pay people that clean your house.
And so if the dispute is he didn't pay, then the deposit to CS 44 LLC is quite relevant.
Your Honor, I'll say two things about that. Number one, it's undisputed he paid the deposit. It is absolutely undisputed that he paid that, and he's shaking his head no. That is false, Your Honor. He filed his own bank records showing he paid the deposit. He, Mr. Clements. And there's no basis for seeking these bank records to show he paid the deposit. What's in dispute here is the return of the deposit. That's what's in dispute. Not whether he paid the deposit or not, but whether it was returned to him. And that's what this litigation is about. And there's nothing in this litigation where anybody asserts that he didn't pay the initial deposit. Your Honor, Your Honor, it is very disconcerting for Mr. Clements to sit there and shake his head at every assertion. And it's absolutely, there is no way as an officer of the court he can tell you that it is in dispute whether he paid the deposit or not. And that's why I wanted a record of this, because this is the kind of behavior that Mr. Clements engages in.
Yeah, I'm with you. Let's hear from Mr. Clements. Mr.
Yes.
Clements, bottom line, as I appreciate it, is that you paid a deposit based on a contract between you and the lessors, and the lessors did not return 100% of that deposit. So you are suing for the balance. So how much money are we talking about here?
Judge, the security deposit was $9,250. They made approximately $2,000 worth of deductions, and they sent me a packet of invoices, nothing written by them, no calculation by them. They sent me a packet of random third-party papers that totaled to approximately $2,000. And then they gave me a conditional check saying this is payment in full. And then they followed that up with an email saying, if you cash this check, you're waiving your rights to any of the $2,000 that we deducted from the check. So obviously I have my...
That doesn't make sense to me.
Which part?
The lawsuit is over $2,000.
No, Judge, the lawsuit is over the entire $9,250 security deposit because...
Didn't they return 7,000?
They wrote on it payment in full, and they required that if I cash the check, they wrote me an email saying, if you cash the check, you waive your right to the remaining $2,000. So they said, if you want to sue us, you can't cash the check. So I tore up the check, I wrote canceled on it, and I mailed it to them. So the full amount and the actual damages from which all of this originates is the entire security deposit, because they didn't unconditionally return it to me. They conditionally said, we'll give you seven.
What if Mr. Eisenhower tells his clients, look, we have no basis to retain the $7,000, and they send you a unconditional check tomorrow? No problem, right? Now we have a suit for the for what they kept, right?
If it was unconditional at that point, I mean,
I'm talking about tomorrow. They send you a unconditional check tomorrow.
I mean, I'm not going to disagree with you that that's what they should do. I totally agree with you, but my damages would still be the same under Texas Property Code 92.109 with respect to the treble damages, because I would still be multiplying by 3 the $9,250. They would be paying some of that now, but yeah, they have zero claim to the approximately 7,000. They never have.
Okay,
and we're making no claim to it, Your Honor.
Well, I understand.
I don't.
And I understand your point, Mr. Eisenhower, non-party way, party way, but I'm just talking about, I don't see that he's not entitled to the bank statements with everything else redacted except the deposits from his monthly, or the security deposit. There's no problem about the monthly payments, is there?
Judge, may I respond on the issues with the purpose of requesting those records beyond just the security deposit?
Your Honor,
my question is, are you suing just because they did not return your security deposit correctly? Because they would be suing you if you hadn't paid the monthly.
They are, Judge. They're what Mr. Eisenhower omitted from his whole spiel to you was that they have a counterclaim against me. Okay, so I moved out on December 29th of 2022. And it's important background information for the jury, because this is an expedited action to a jury trial, that I paid timely and in full $135,000 throughout the entire term of the lease. I move out on December 29th. They never sent me a letter never sent me an email saying, you owe X amount of rent, you owe a late payment. The very first month that I was there, when it was December 1st, the defendant was already emailing me that I hadn't paid my rent on December the 1st of 2021. So they let it go 4 months with me, having left that unit. And only when I requested under Texas Property Code a statement of any late fees, a statement of my account, essentially, all of a sudden they claim that I owe $15,000, and they now have a counterclaim against me. So they're claiming that, that I moved out early, I didn't get proper notice, and blah, blah, blah. But as just a background fact for the jury, I need to be able to show that every single month, and including the security deposit, I paid in full, I paid everything. And that when I moved out on December 29th, which actually was early, and I was actually owed money because I didn't stay all the way through December. I need to be able to show not just my own bank records. My bank records I have, but defense counsel has refused a stipulation. I had a chart that showed when I paid it, when it was deposited, when it was received. He refused the stipulation of the chart. And I don't just want to show one side. You know, my records are my side. I want to be able to show the other side of when the money was
so
received.
they're claiming you didn't, if the lease was for 12 months, correct?
No, Your Honor,
was
it was for
over
longer, it was
13
for
and a half.
longer than 12 months. It was for longer than 12 months. He moved out early. Our hope was to resolve this matter. He's refused to resolve it.
All right,
As a result of his refusing to resolve it, we've brought the appropriate counterclaim.
okay, so what was the term of the lease?
It was from November 10th, 2021, originally, through January 10th, 2023. And what happened was at the end of,
And what per month?
You guys, Credence and Mikey are live. There's something, the chase going on. You know how my ADD can't handle that kind of shit. Somebody needs to get over there and tell me, get on that, okay? I'll keep going here because I have 46 people that I love and care about. But y'all know we like chases.
It was $9,250 per month.
Okay. So it's I can't multiply that times 12, but whatever that is, you claim you've paid that in full. I take it.
Yes, if you do the prorating and the whole deal, it comes to, I have the exact number I can tell you. It's a little under $136,000.
What are you talking about prorating?
Judge, so the original lease term was through January 10th of 2023. And at the end of November of 2022, the condo building I lived in was actually raided by criminals. There were 12 different units that were broken into by a criminal gang. Property, watches, jewelry, all sorts of things were stolen.
Sir, I don't need to know that. I want to know.
What? What did he just say? Oh, okay. We're gonna just flip quickly over here to my boys.
Where is he at? Where go?
First things first. Everybody that's in here, y'all must be subscribed to Credence and Mikey because they are literally my boo things, and they do these live chases, which are awesome. It's just Mikey there right now. Really, what should happen is I should go and host with Mikey the live chases, but we will continue to watch this case because it goes on for quite a while and I find it really interesting. So don't worry, we're not going to stop that, but I'm going to put this in part of the screen. So that's what I've decided I'm going to do about it. But I won't feel bad if you go over there and watch them. I know the ADD feels, you know? And what do you guys think so far, other than that Bradford needs to buy the rest of his couch?
You signed a lease
So
for
we agreed to
2
move
years.
out.
For 2 years.
No, it was about 14 months.
What Mr. Clements is leaving out.
January 10th, 21 to January 10th, 23 is
November 10th, 2021
okay, November 10th.
through January 10th, 2023.
Well,
We then agreed to, by email agreement, that my termination date would be December 29th.
That is
2022.
false, Your Honor. That is false. He knows it's false. What Mr. Clements is not telling you is that the lease had a requirement of 60 days notice to leave. And through the process of his emailing my client, he failed to live up to the agreement and failed to give the 60 days notice. And that's what the counterclaim is about. The counterclaim is not about whether he paid the rent for the time period he was there. It's his failure to pay the rent for the 60 days notice he failed to give. That's what the counterclaim's about. The counterclaim doesn't have anything to do with whether he made payments November 2021 to December 29th, 2022. The counterclaim doesn't have anything to do with that. Nobody disputes that he paid the $135,000. He's got the records that show he paid it, and nobody disputes that he did.
Okay, so if he didn't, and he made no payments to anybody after that, correct?
That is accurate, Your Honor.
So the bank records of deposits by the LLC / the Sings for 11/10/21 through 12/29/22, that's irrelevant.
It's redundant, Your Honor. It's
Right.
the same stuff he's already shown us. It's not in
Right.
dispute in this lawsuit.
Right, I agree. Okay.
Judge, I didn't get to answer there were multiple reasons for requesting the records. Part of which is, they did $2,000 worth of deductions from my security deposit. And if you're going to deduct from somebody for specific amounts, a Molly Maid cleaning bill, a guy who supposedly painted a ceiling, a move out fee, utilities, there's $185.18 utilities that I paid. So they've deducted $185.18 as though they.
That will all come out in trial, sir.
The point is to connect. If they've got a deduction of $185.18, I should be able to connect that with the fact that it actually was paid.
Right, Your Honor. And here's the point with that, Your Honor. We have produced the documents that show payment, including a check from CS44 LLC showing Mr. Flegel was paid. There is a pending discovery request from Mr. Clements for other evidence concerning payments, which is not yet due, which is due July the 1st. And we will respond to that timely as we have all the other discovery in this case. But to willy-nilly say he's entitled to go through all of the bank records of an entity that's not even a party to prove payments.
You're filibustering your own bill.
All right, I apologize, Your Honor.
The motion to quash is granted. Now, what other motion did you want me to hear today, Mr. Clements?
It's a motion for virtual hearing.
Okay. Well, I think under the local rule, let me bring that up. Motion. Let's see, a motion to compel inspection.
Sorry, this is interesting. They're already on Zoom, but listen to the arguments and a little bit becomes clear as to why the Bradford had to file this motion like he did.
That then we don't have that on the docket.
This was on June 5th.
I got it. Okay. Okay, we got a hearing scheduled June 29th. And the local rules are that a Zoom hearing can be held by agreement. But if there's no agreement, then the party requesting the hearing must show good cause. So you may proceed on your motion, Mr. Clemens.
Yes. So, when I moved out of the Austin unit in early January, I moved to Connecticut, which is where I am now. And, there are two really important rules that apply to this issue. One is Texas State Judicial Administration Rule 7F2, and the other is Texas Rule of Civil Procedure 21D. Rule of Texas State Judicial Administration 7F was actually amended to become effective on April 1st of this year. And that rule is, looking at specific, it's, as to make it clear, I'm not trying to have a virtual trial. I will come down to Austin for a jury trial that's scheduled in October. But this matter already has over $3,000 in court costs. Defense counsel had written me an email saying, as to stipulations, you will get none. I've got an exhibit that shows defense counsel saying that. Defendants evaded service. You'll see in the docket that on March, I think it was 10th or 15th, Judge Gamble granted substitute service. So it's the MO has been to raise my cost, to raise the burden on a very simple motion. The motion that I have for June 29th is a motion to compel inspection, because they provided me 14 pictures of the unit. They never provided me a date the pictures were taken. They weren't taken after any painting or after any cleaning. So I've never even been able to see that any painting or cleaning was performed. They were taken with a very large zoom. So I need to be able to go in, have an agent go in and take pictures to see whether or not any work really was performed and compare it back to the pictures that I have. Because when I moved out, I have 80 pictures showing that I left the unit in immaculate condition. And I need to be able to compare to whatever work was performed and have dated pictures and have a photographer that took those pictures. So the hearing on June 29th, is a 30-minute short central docket hearing that was brought about because I told, because the defendants had this unit on the market to be rented out again. And in mid-April, they took the listing off the market. And I was worried that they're either about to have a new tenant come in and change things up, or they're about to move into the unit themselves. So I asked defense counsel at that time for an inspection that would occur 30 days after the discovery period began. And defense counsel told me he would, his due date would be that day, 30 days after the discovery deadline began. And what he ultimately did is he didn't respond at all. So I followed the rules that say when you don't respond to a discovery request, that you basically are granting the request.
Oh, Mr. Ice Noggle does not appreciate that. Look at his frown. Look at his frown. Oh man. Do you guys think he had that couch shipped up to Connecticut for him? And they lost two parts of it, and that's why he only has the corner?
And I asked what days the defendants would be available for me to have the agent come in and do an inspection. He refused that. And so that's why we have this hearing on the 29th. And it's just a 30-minute hearing. I'm in Connecticut. For me to make an 1,800-mile trip on such a simple motion doesn't make sense. Texas State Judicial Administrative Rule was just amended to provide for video conferencing. And if you look at page 5 of my motion, you'll see a district or statutory court judge must, to the extent consistent with due process, consider using methods to expedite the disposition of cases of the court, including the use of teleconferencing, video conferencing, or other available means in lieu of a personal appearance for motion hearings. So again, this is a very discrete issue. You can see multiple cases from the Texas Supreme Court where they're encouraging the use, back then it was appearance by mail or by teleconference, to expedite actions. If I am required to be in person at this 30-minute hearing on the motion to compel inspection, then we're going to have to reschedule that hearing. I won't be able to make it. It's going to push back the deposition that defendants have scheduled on July the 3rd. It's likely going to push back the trial date. So there's really no reason. And you can go and look at the different factors under Texas Rule of Civil Procedure 21D, which I lay out on pages 7 to 8 of the motion, where, again, a very simple hearing, no witnesses being presented. All of my evidence is in a bookmark PDF, just like you're looking at right now. And to have me come all the way in from Connecticut for that 30-minute hearing is not what the Texas Supreme Court had in mind when they just amended Texas State Judicial Administrative Rule 7 and when they just passed Texas Rule of Civil Procedure 21D. I mean, it's precisely for situations like this. I have committed fully to coming and having an in-person jury trial. The Texas Supreme Court emergency orders have to do with, somebody who's refusing to be at a jury trial in person, but that's not me. So what really applies here are the two rules I told you about. And all I'm asking for is to be able to have the virtual hearing on June the 29th so that the case can be expedited and move along to an in-person jury trial in October of this year.
May I respond, Your Honor?
You may.
Your Honor, as the court fessed out earlier, this is a lawsuit. It's essentially over $2,000. Mr. Clements, in describing the lengthy description he gave you, and I'm going to use just one of the items that he referred to as an example. He gave you this example that counsel told him he would get no stipulations. And the first thing I would tell the court is that wasn't me. That was previous counsel. I have attempted to work with Mr. Clements on stipulations. I sent him documents that I would stipulate to. He refused if I did not stipulate in the manner he wanted, which was lengthy 4, 5, 6-page written stipulations that stipulated to things that no practicing lawyer would ever stipulate to. And as a consequence, we've been unable to stipulate because in Mr. Clements' world, stipulation means something entirely different than it means in my 40 years of practice. Now, using that as an example, Your Honor, and I want to make the point I'm trying to make here. We had a hearing, Your Honor, in front of Judge Iserloh, maybe about now almost 2 months ago, which was this same hearing. It was an attempt to have the hearing on the motion with regards to striking the need for ADR. And he filed a motion. I won't go through everything involved in it other than to call the court that I was in the middle of a field on a telephone participating in the hearing. And I told Judge Iserloh then, I said, if you let this man do these hearings remotely, there are going to be tons of them. And that, Your Honor, is what is happening here. That is what is coming. Is because he doesn't have to come here in person. He doesn't have the same requirements, restrictions, economic issues that somebody that's hired counsel in Austin, Texas to represent them would have, or that somebody who lives here would have. And so what that has done is it has emboldened Mr. Clements to file motions and have hearings on every small insular issue in a $2,000 lawsuit. Now, in our hearing on the motion to strike ADR, we were in front of the Chief Administrative Judge, Judge Meacham. And Judge Meacham told him while he was telling her that he would never, ever settle this case. He would never, ever consider mediation or settlement, which is specifically what he told her. She said to him, you realize what that means is that Mr. Eistogel may well be able to have you come here for every one of these hearings. She specifically told him that, and yet we continue. And that's the problem with this, Your Honor. This is a $2,000 lawsuit that with reasonable counsel and reasonable people on both sides should be settled. But it can't be because of Mr. Clements and his assertion that he will never, ever, ever settle this case. And so he is running up the expenses. I get lengthy emails from him whenever I won't agree to whatever outrageous idea he has. I get lengthy emails from him telling me that I am the one raising the costs and I am the one causing all these costs to go up. But I'm not the one who, Your Honor, within 2 weeks ago filed 104 interrogatories in this case. 104, Your Honor. And so we're litigating this case like it's worth millions of dollars. It's $2,000. And it's not the only, but one of the primary ways to stop somebody from doing something like this is to make them come here and have hearings, all these hearings they want to have. And he can spend all the money, or he can hire a lawyer in Austin. He can do what a regular person has to do. And that's our problem with this. In a vacuum, if I have counsel who's here in Austin contacts me and says, let's do something by Zoom, let's do depositions by Zoom, let's do a mediation by Zoom, I'm all Zoom in, Judge. Everybody that practices these days is all Zoom in. But at this point, we're simply being abused by Mr. Clements. He's abusing the process. There are other cases in other jurisdictions in which he is doing the same thing. And he just needs to be stopped. And this is a way, in my belief, to stop him from doing this continually.
Well,
Judge Matter,
I'm not going to hold you to this, but on the inspection,
Zoom, zoom, zoom. We're going to them.
If you were to conclude, Mr. Eisnagel, that he was entitled to an inspection, then there would be no need for the hearing on the 29th. And by agreement, Mr. Eisnagel Mr. Clements could hire a videographer to video the premises.
So let me make a couple of comments.
It would certainly be less cost than a round trip air ticket to Connecticut. But
let me make a couple of comments about the inspection, Your Honor, since Mr. Clements brought that up. And I realize this is not the hearing on the inspection, but I know it's on the judge's mind. So let me make a couple of comments about it. Number one, I gave Mr. Clements, I told him that if he would agree to 3 items, I would go to my clients and talk to them about allowing the inspection. And those 3 items were that he make the person that does the inspection available within 7 days of the inspection. Number 2, that he provide any photographs or videos that person takes. And candidly, Your Honor, at this point, I feel like Rick Perry, I don't remember what the 3rd one was. And the reason I don't remember, Your Honor, is because Mr. Clements rejected it out of hand. And Mr. Clements, if you'll understand something, Your Honor, my clients had a horrible experience with Mr. Clements. And I'm not going to go through all of the lengthy issues, the threats he made to sue them repeatedly. I'm not going to go through all of that, Your Honor, but I'm going to tell you their experience with him was horrible. They do not want to see him ever again. They don't want him anywhere near them. And so where we end up, Your Honor, is my clients own the condo next door to this condo that they rented. They don't want him there. And he has no real rationale for being there. What he's brought up is these photographs that were taken. And I want to make a real good point about that, Judge. Yes, he took a ton of photographs when he moved out, but he didn't photograph 2 things. Number 1, he didn't photograph the master shower stall door, and he didn't photograph one of the windows. And what was on that window was a tremendous amount of duct tape residue. Apparently something had been duct taped all over that window. That's what they had to clean, one of the items they had to clean. And the shower door, excuse me, was just caked with residue. And
What kind of residue was his shower doors caked with? I at first thought the duct tape residue was in the shower, and I was like, hey, you know what? If you've got a fucking party house, you're paying 10 grand a month for renting it, yeah, you better be getting some pussy. So I would hope he had some gear set up in the bathroom, permanently affixed. I would hope he would use something better than duct tape, but seriously, like, I've been a cleaner before. You can't charge $2,000 to clean that. Even if you needed a whole new fucking shower door, right? The shower door residue is weird. And he wants a videographer. Like, can you imagine? Just listen to that for a sec. Your normal day to day is like bar mitzvahs and weddings and like engagement parties and stuff. And this dude calls you up and he's like, could you do a videography session for me? Oh yeah, what would you need? Well, I'm gonna be at this really nice apartment downtown and I'd really like you to zoom in on the shower residue. Oh, oh. I think they're both being petty. They could have. I don't know how much he wants to settle this lawsuit, but couldn't they have just sent him back the whole deposit and ate the $2,000? They own both of the apartments that are up there. One of which he rented for like $9,300 a month. So I don't know. Clean your toys, clean your boys.
that's what they had to clean. We sent Mr. Clements those pictures. In response,
Before and after.
we sent them when we received them, which was from the folks that went in to make the people that were going to lease the apartment for us after he left. They took those photos and we sent them to him and said, here's the issue. If you want to know what the issue is, here's what you left dirty. Here's what was required to the expense to clean. And what's important, Your Honor, is that's the two things he didn't photograph. And so he photographed all this other stuff right when he left. He has whatever he thought was important to photograph when he left, he photographed. We then have photos from before the cleaning was done, before January 23rd, that shows what was going to be cleaned. He is now taking those photos and trying to bootstrap that into, I get to come look at the apartment. Why? We are now in June. He was last in the apartment December 29th. We're 6 months past when he was there. What possible thing
Judge, may I please
could be
respond?
gleaned or discovered?
Pardon me, hold on.
What possible thing could be
Hold
gleaned?
on just a second.
Sure.
Somebody,
Are you Creed frame,
Thank you,
Bradford,
Court
or are
Reporter.
you just being a baby? He's being a baby. He's not Creed frame.
Probably telling us to slow down.
Wasn't me, Judge.
it wasn't you? Well, we need to move along.
What a baby. He didn't even admit to it that it was him. Oh, wow. That's odd. Have you seen that before? Let's go back. That was obviously him. And let's just do a play-by-play on it.
Done before January 23rd that shows what was going to be cleaned. He is now taking those photos and trying to bootstrap that into, I get to come look at the apartment. Why? We are now in June. He was last in the apartment December 29th. We're 6 months past when he was there. What possible thing
Judge, may I please
could be
respond?
gleaned or discovered?
Pardon me, hold on,
What possible thing could be
hold on
gleaned?
just a second.
Sure.
Somebody, I think the court reporter, Chuck,
Probably telling us to slow down.
Bradford.
Wasn't me, Judge.
wasn't you? Well, we need to move along. I don't, and I understand, Mr. Snuggle, he is, well, you and I are characterizing it as a $2,000 lawsuit. He has pled violations.
This judge is having such a hard time getting this out. But seriously, have you ever seen what was that? He totally jumped in. He said, I want to be able to respond to that. And then when he said, excuse me, who said something? He didn't even respond.
I think they're in the property code, but I'm not sure about rental deposits and the treble damages. And so he says that could be a $27,000 lawsuit, or maybe even a $6,000 lawsuit. But regardless of what the pleadings do, I do think that y'all need to get this thing going. So I'm going to deny the motion for a remote hearing on the 29th. You'll prepare both of those orders for him?
I will, Your Honor.
Nagel?
All right. Thank you, Your Honor.
I lost.
May we be
Judge, am I able
excused?
to-
You may be
May we be excused, Your Honor?
You may.
Thank you.
I've lost Zoom.
No, you didn't, Judge.
I'll go help you, Judge.
Just wait for it. It gets sort of funny. And then I'll cut. His clerks have patience and passwords. Also, she's a ghost. There's the reason he hasn't retired, Lawrence says. Oh, getting out his good specs right for this one. Thanks, Jerry. I like her skirt though. That is so like Saved by the Bell-esque. Look at these generational gaps and working together. I'm just so happy. She must be 60 years younger than him. He's like, I'm off Zoom, but I've got my screen record on and I'll be checking that one.
All right. The next case is D1GN. Well, let's say,
Let's just keep watching for a bit. I caught that part.
Jacqueline, do you need a short break?
Oh,
I'm fine, Judge.
Okay,
oh, he's so nice,
The
asking
next-
if she needs a break.
I've called the case. It's State of Texas versus Baroom Automotive et al. If the attorneys would announce their appearances for the record.
Good afternoon, Your Honor. This is Assistant Attorney General James Holian for the plaintiff, the state of Texas.
Okay,
Good afternoon, Your Honor. David Gringer, Wilmer, Cutler, Pickering, Halendorf for the Vroom defendants.
all right, sir.
I'm sorry, what? You're gonna have to go back and say that again, sir. I thought you said something about Gryffindor.
This is Assistant Attorney General James Holian for the plaintiff, the state of Texas.
Okay,
Good afternoon, Your Honor. David Gringer, Wilmer, Cutler, Pickering, Halendorf for the Vroom defendants.
all right, sir.
This is Don McGee, also on behalf of RIM.
Right. Thank you, Mr. McGee. Whose motion to compel?
The state's, Your Honor,
And about when was that filed?
May 18th.
Okay. All right, was there a response filed?
There
Yes,
was.
Your Honor.
About when was that filed?
June 5th.
Vroom. That's what I heard. The vroom vroom Zoom court.
Defendant's opposition to plaintiff's motion to compel.
I'm laughing so hard at
Got
that,
it
Billy.
up.
Billy said, I know the spell to compel, Your Honor. I will start the magic duel.
Your Honor, there was also a reply brief that we filed on June 9th. I don't know if you have that.
Do they need to increase the font size for him? You know how many people's lives I've changed just by like control
No, the last
plus plus the button right beside the
document I have
backspace.
in this database, wait, is the it goes from
Right up my alley.
524 notice of appearance to 6/5 the opposition, and there's no other document loaded. And who filed the brief? The state?
Yes, the reply brief that was filed on Friday was from the state.
Oh, this past Friday?
Yeah. Yes, Your Honor.
I guess since it's not in the database that I'm looking at,
Hold on, I'm a little confused now. So the state of Texas, through the Attorney General's office, is suing this company? Oh, fuck. I'm hooked, Judge. Just tell us a little bit more.
if you could email it to the court JEA.
No, don't you dare
And
give
she
out that
can
email.
clarify it.
Okay.
Don't fucking do that, Judge. I hate to have to. Where's that cup from, guys? Where is he drinking from? Where is that from? Was that Burger King? Was that a...
This is emailing that.
Yes, please.
All right. Your Honor, this case is not a $27,000 case or a $2,000 case. Just to give you a brief background, this is an action filed on behalf of the state of Texas against Vroom Automotive LLC and Vroom Inc. Collectively, I'm going to refer to them as Vroom for this afternoon's hearing. And Vroom is a Texas company that operates a website, www.vroom.com, where they buy and
Not a
sell used
sponsor.
vehicles online. And the Consumer Protection Division at the Texas Attorney General's office filed this petition in April of 2022, alleging that Vroom violated the Texas Deceptive Trade Practices Act, DTPA. And in that petition,
DTPA sounds like my brain just thinks DP. You're such a dirty bitch.
they identified numerous alleged violations. We had the Office of the Attorney General and the Better.
Also, you guys know I've worked at a used car dealership before and sold cars, so right up my alley. Secondly, the Assistant Attorney General absolutely did just throw the previous case under the bus. Like, he literally was like, this is not a $2,000 case, Your Honor. Wow. We're going to keep watching. And I think we are going with Judge Pawpaw so far. If anybody has a better name for Judge Pawpaw, let me know. But I'm going with Judge Pawpaw so far. But Pawpaw fierce, I'll tell you something. He's just getting straight down to business. He basically solved that last case. He was like, so if you do this tomorrow and you do this, we could be down to almost nothing. I love it. I love it, love it, love it. Between Judge Pawpaw and Dismissal Dan.
Business Bureau over the last 5 years or 4 years has had over 6,000 complaints about issues. So you've got the Better Business Bureau over the last 5 years or 4 years has had over 6,000 complaints about issues. So you've got, the Consumer Protection Division is alleged that they've misrepresented the conditions and characteristics of the vehicles they sell, that they've misrepresented their ownership of vehicles when they put them online for advertising, selling cars essentially to consumers before they had possession of title. We've alleged that they've failed to disclose higher insurance premium requirements for non-Texas consumers when they couldn't transfer title timely.
Okay, I have to say something though, and I've been in the car business for a while. When you buy used cars, you usually do try and sell it before you buy it. That's how you make money. It doesn't behoove you to buy in a car and then be like, oh, I'll find somebody that will buy this. A good wholesale car buyer and used car buyer is a very valuable resource to dealerships around, because the dealerships have to take in the cars, but they can't always move them. And so they need to have a company like Vroom or a company like a wholesale car company who comes along and is going to take them, and they're going to take the cars when you need them to. Like, I'm being serious. I know people in the business, and so you build a relationship by handling some hard to deal with cars and getting good deals on other cars. Like you know, it's a business. It's an old guys club basically. And so when what I'm saying is like if they it doesn't actually I just wrote it down. I'm like, "Oh, they're selling the car before they have possession of the title." Well, to me that's not ideal with a customer, but it's totally not unheard of. Like you got to do a bunch of trades sometimes to get the right car to sell. So, of course you're selling, you know what I mean? So, I don't know.
And those folks had to get additional temporary stickers or permits. They also had to increase their insurance. We've also alleged that Vroom has failed to disclose and misrepresent financing details. I think the DMV calls it a spot delivery scam when you sell a vehicle to someone, deliver it, and then call them up a couple days later and say the financing didn't go through. You need to come back and pay more. And also, we've alleged that they've misled consumers about their ability to transfer timely title and registration. So by and large, there is a umbrella of different DTPA violations that the state's asserting in this action. I want to start with the ask. What is it that we're asking for today? We're going to be here till 7 at night if we go through each and every individual interrogatory and request for production of documents. So that's not my intention. I want to try to hit the high points for the court. And I'll do that by starting with the ask. What are we asking for? We're asking the court to overrule and strike defendants' global objections. They do several pages of global objections to their written discovery. And I guess I should start with a little background.
I thought this was a motion to compel something.
Yes, compel discovery.
Your Honor, I didn't realize we were doing jury speeches this afternoon. I'll have to go back to the drawing board.
This is a motion to compel, Your Honor. I'm just trying to set a little bit of the background for what we're asking for here today.
On a motion to compel, that's different than a motion to strike. That's two different motions.
All right.
So you got, I'm looking at page 2 of your motion. I'm looking
yes, Your Honor.
Looking at the bullet points.
Yes, Your Honor.
Bullet point 1, strike. Bullet point 2, overrule. Nope. All right. Now we find the word compel. So
yes, Your Honor.
Bullet point 3 and 4 is what I'm hearing today.
Yes, Your Honor. So bullet points 3 and 4 are to compel defendants to amend their responses to the request for production and interrogatories, and to compel defendants to produce all responsive non-privileged documents in their possession, custody, and control within 10 days.
Well, that's certainly pretty vague, but go ahead.
Yes, Your Honor. Let's get into some of the details. Essentially, defendants in their responses to interrogatories and requests for production have inserted a jurisdictional argument that they shouldn't have to produce all responsive documents for jurisdictional reasons. They essentially state that the documents about their transactions that occur out of state with an out-of-state vehicle license have no nexus to the state of Texas, and therefore they shouldn't have to produce them in response to discovery. And what we're asking this court to do is to compel them to produce all responsive documents because this is a Texas company. Defendants have also tried to
understand your definition of all responsive documents may be different than my definition, may be different than the defendant's definition. That's all responsive documents is so vague.
We don't know, Your Honor, what documents they're withholding.
Well, yes, you do. If you want the sales contracts of all cars sold from January 1st, 2015 till May 31st, 2023, that's pretty specific.
Yes, Your Honor.
Okay.
And our discovery, which is attached as exhibits A and B to the motion, seek those specific types of documents as it would relate to DTPA violations.
All right, let me get to that. What do you know what page that exhibit's on? A and B? I'm talking to you.
Yes, Your Honor. It's page 25, or I'm sorry, page 21 is the start of exhibit A.
Okay.
Judge looks so scared. Does he not? He looks like somebody's literally electrocuting him.
Okay, that's easy. No problem. No document sufficient to identify all customers who purchased a vehicle from Vroom. Okay, that's easy. No problem. Paid taxes and fees for registration and did not see valid title and registration in their name within 60 days of delivery. Okay, that's easy.
Is it easy, Judge? Is it quick, though? It's not feeling quick. Maybe it's easy,
right.
but slow.
So you want me to compel them? Have they responded at all to this motion to produce?
What they've done, Your Honor, is offered their own limitations on what they're willing to produce, and that they're willing to produce that supposedly by June 30th. But they in those responses, they have conditions and caveats abound that say if this is too burdensome, we can seek additional time. If this is too much on us, we can have further meet and confer. So the short answer is no, we haven't received a complete response to documents from this request for production. And they have limited that scope by inserting a jurisdictional argument as well as their own time limitation on what they should have to produce.
Your Honor, if I may, David.
Yes, sir.
This is not accurate, and or I'm not sure it's productive. There are two overarching issues here. First of all, Mr. Hoying's wrong. We've met and conferred with them, and we're willing to continue to do that. We're making a very substantial production of we've already produced tens of thousands of documents to them, a lot more than is typical in a case like this. My client is struggling coming out of the pandemic. It's resource constrained. It's already done.
Why is this being handled in front of a pro tem judge or a random judge? Is my question now. Like, this is probably a case that should be handled in like with a judge over time. Like if they're producing 10,000 documents, that's nuts.
A tremendous amount. This motion has very little to do with anything other than trying to increase our costs. And it was done in the wake of a settlement conversation. Mr. Holian was not prepared to move to compel anything. This was done to try and intimidate my client. There are no objections here. There are two discrete issues about whether the DTPA applies wholly outside of Texas, a question the Texas courts have already answered that they do not, and whether, that's question one, it's easily resolved in Vroom's favor. Question two is whether Vroom should be required to go back before 2019, which predates any of the allegations in this case. And we submitted a declaration explaining why we can't do it for under $5 million because of the burden, because we don't have the systems. Those are the only two issues. And they're very straightforward. One is compelled by the Texas Supreme Court. The other is a literal impossibility because of the burden and cost involved. Otherwise, there are no issues. So what I suggest we do is we're going to finish our production on June 30th, no caveats. We've offered repeatedly to meet and confer. Rather than go through all 35 requests they have, plus another 37 requests, plus another 15 interrogatories, let us finish our production, which is what we suggested to them. Let them look at it. If they identify any deficiencies, instead of parsing our objections like it's some kind of holy grail, let them review the actual materials we produce in full, which again will be done 18 days from today. And if they see any problems, if they think in addition to the tens of thousands of documents we've already produced, there's more that they need to make their case, we're available to meet with them and confer with them. We don't need to waste your time, the court's time, or anyone else's time. We're making a big production. And if they see deficiencies, they can bring them to our attention, and frankly, we'll correct them. But if not, at that point, we can have a focused conversation with the court.
So is your ongoing production through, did you say June 30th?
We will be complete with our production as a part, they're talking about
is in response.
Get corrupted or something. That's all we're saying. It's our present intent, and we have every full intention of completing our production in 18 days.
Okay. Are you saying that you're producing that under a request for production, correct?
37 of them, to be exact, plus some interrogatories, yes.
Well, what I'm saying, it says a request for production.
Yes, there are 37 individual requests, all of which are the subject of Mr. Holian's motion, plus a number of the interrogatories they serve. So, but the bottom line is, yes, we're not producing them, and we're producing them in response to the RFPs.
In response to what?
In response to the request for production, and we will be complete.
Who established the June 30 deadline?
We told them that was the earliest date we could complete production, and they didn't do anything for months.
Your Honor, may I respond?
Yes.
Well, first off, I don't think this needs to be a hearing where we're, categorizing the way that this motion was or wasn't prepared. The simple fact is the plaintiff served this discovery in December, and we don't have a complete response to the request for production or interrogatories, period. And counsel has misrepresented the issues. This isn't just two issues. They have inserted objections that make that discovery that they are gonna claim to complete by the 30th. We don't agree that what they're willing to produce is complete. They have already asserted these jurisdictional arguments or pre-suit investigation arguments or timeline issues that we frankly don't think are supported by any of the rules of liberal discovery, where this court must construe the rules liberally to allow the plaintiffs an opportunity to get the fullest knowledge of the facts. And in so doing, defendants have already asserted these arguments. They did so again in their supplemental responses. And so whatever they produce on the 30th is still going to be subject to those objections. And that's why we're here today. This isn't an untimely or early motion. This is simply the fact that they've decided to stand by jurisdictional objections and limiting scopes of what they're willing to produce in the first place.
Your Honor, I'm not sure Mr. Julian is, and frankly, this is why we needed to continue to meet and confer rather than him rushing to the courthouse and filing this motion to try and intimidate my client, which didn't work, by the way. The bottom line is, I'm trying to be pragmatic here. We've already produced tens of thousands of documents. Our deadline is in 18 days. He's seeking for it to be moved up 8 more days, which is ridiculous, and we can't even do it in 8 days anyway. Let us finish our production on June 30th. Mr. Julian should look at that production rather than deem it deficient prima facie. And if he still has problems, he can't make his case out with what we've provided or doesn't think he can, then he should come back to us and raise the issue. He said he didn't have 2 issues, and then he just gave you the 2 issues I identified as the issues. So I just think he's confused about what we're saying and what we're doing. And so what I'm saying is, let's get cut through the confusion, because there are 52 requests here. And let us finish our production. And if Mr. Julian has a problem with the production, once it's complete, he knows where to find me and he knows where to find Your Honor.
Well, let me ask this. For some reason, I'm having trouble loading your response.
My response brief?
Oh, okay.
We also sent a courtesy copy if that's helpful.
No. Now it's working. Because if the issue,
This does seem ridiculous. If they have an existing deadline of the 30th, I don't think it's fair to ask them to try and compel before that. Ice Noggle wouldn't let this happen. Ice Noggle would be wiping the floor with Holian over there. I think Gringer is exactly what I picture a lawyer for a car company to be.
is
Also, hi,
in 18
Shane.
days,
I'm still here too.
you're not going to produce anything that had out-of-state purchasers because you believe that is not relevant because the DTPA would not apply to those persons. If you're telling me that, then we might as well litigate that today. So you know
Not what we're doing. What our issue, we agreed, even though the DTPA does not require, where the sale is to, we'll do it now, we can litigate this issue on summary judgment, where the consumer is out of state and Vroom made the sale or did the transaction through its Texas-based license, we are giving Mr. Holian the materials, which is why I'm saying, let's wait and see. Now, there are a very small portion of transactions that Vroom does not make through a Texas-based license to not Texas-based consumers. And there, the law is clear, they have no jurisdiction. And we're not providing those materials because there's no jurisdiction and it's not even close. So if we want to discuss that very narrow slice of an issue, not Vroom sales to out-of-state consumers, which he's getting all the materials for, but rather Vroom's, the narrow slice where it's not operating as a Texas entity, where it's licensed in a different state to a consumer in a totally different state. Sure, I'm happy to litigate that issue, but it has been decided by the Texas Supreme Court that the DTPA does not reach that far. And because then there's a presumption against extraterritoriality, and there's no assertion of extraterritoriality in the statute.
well,
Your Honor, may I respond?
very, very well. Let me ask him a question. I don't know whether the Supreme Court has looked at the decision to I mean, if you have person A sitting in an office and they say, I'm selling under our Texas license to a consumer in Kansas. So you get that information. Person B is sitting in an office right next to him in the state of Texas here, and they're using a license not granted by the state to a consumer in Nebraska. And you're saying that Texas has no jurisdiction because the second person is committing DTPA actions or violations, and simply because he's using a Virginia license, that the state of Texas can't come after that person. Now that may be a different deal, that you're operating in Texas under a Virginia license, and you can't do that. If you're going to operate in Texas, it has to be under a Texas license. I don't know what the law is on that. I don't know if there's any case law on it, but I think that's what you're saying.
Well, first of all, the physical location of the person who's making the sale, Vroom has offices outside of Texas too. Vroom is incorporated in Texas. That is true. But as Your Honor, I'm sure knows, auto dealerships operate on a state-by-state regulatory level. So what we're saying for purposes of this motion, and I don't think our compromise to the plaintiffs should be used against us. Our view is the DTPA operates to protect Texas consumers, as courts have said. We're willing to, for discovery purposes, go broader than what the DTPA requires. What we are not willing to do is say, okay, you're selling cars to a customer with no ties to Texas, and you are doing so under a different regulatory regime, which is the dealer license of a different state. This transaction has nothing to do with Texas. Nothing to do with Texas. There's a whole nother jurisdiction that wants its say over those sales. And so what we're saying is,
But you're in Texas. As long as you're not in Texas doing it. But it sounds to me like you're in Texas. And you're like, we're just like pretending to be Delaware.
let's say it's Florida. That's a Florida issue. If you're selling under a Florida dealer license to a
My question, can you be physically in Texas and sell under a Florida license?
I believe that is permissible.
I'm not sure.
Well, I mean, no one's arguing otherwise here, but I believe it is, as long as you're, dealing with title and registration in Florida. So I don't think it's not legal question, but I think it's a different regulatory regime, and Florida has the interest in regulating that transaction. So again, we compromise. I actually don't think there's jurisdiction over
Texas has the interest in regulating people who are selling goods and services to consumers, regardless of where the consumers are. If they are doing that in Texas, then the state of Texas has an interest in regulating that.
Well, it may have an interest in regulating it if it passed regulations, but the DTPA does not reach that far. But again, we have not, once the license is for a different state, it brings in a different regulatory regime, and the consumer is in a different state. That's a transaction for which Texas has no say and no interest. And they're getting plenty of discovery as it is. So again, this was the exact question the Supreme Court dealt with under the Antitrust Act, which has the same language and no specificity. And the law and the Supreme Court held that unless the legislature expressly says this needs to be applied extraterritorially, then it doesn't. And that's the issue here. That's the end of this issue in terms of jurisdiction. So fundamentally, again, where a Texas license, a Texas entity is at issue, we're giving them the discovery and we can put off this issue more broadly for another day. But in the very short term, when they're already getting tons of documents, the incremental documents that we're not giving them, which are very small on this issue, are one where the Supreme Court has spoken, and it seems crystal clear to us that there is no jurisdiction. And fundamentally, this is a statute that's about consumer protection. It's a Consumer Protection Act. So it matters is where are the consumers located? No court has ever held that Texas has that the DTPA extends to transactions where the consumer has no nexus to Texas. They don't cite any and none exists.
Okay, very well.
Your Honor.
I'm going to abate this hearing until July 1st. And at that time, the Attorney General's office can determine whether or not they want to move forward on this motion, because what you have given them on June 30th is insufficient.
Your Honor, if I may, I just wanted to address the arguments of counsel. Like, you know, he's talking about the Coca-Cola company case where the Texas Supreme Court addressed whether a Texas court could adjudicate an anti-competitive injury occurring in another state under, you know, the Antitrust Act. And in so doing, the Supreme Court focused on the policy considerations implicated of antitrust law, and that's the key. Coca-Cola is inapplicable. The case didn't involve the DTPA.
Well, I don't have that matter before me right now. So another judge at another time will hear that argument.
But Your Honor, to the extent that that argument goes to the fact that they have already limited, improperly in our view, limited the scope of what they're willing to produce on the basis that there's no nexus to Texas. I mean, the DTPA sections that counsel keeps citing are in reference to the consumer portion of the act, the 1750 portion, whereas 1747.
I'm sorry, sir. Are you just going to gloss over nexus to Texas as if it's not the best fucking slogan that we've heard all goddamn day? The nexus to Texas is here. I don't know, but I just know it's gold. Okay. We're going to finish this off tonight. We'll see what happens in the rest of this case. I'm making some mashed potatoes upon request. Got an order into the kitchen. I was just did you, Richard? I have a small screen that I'm looking at today instead of my big one normally, so I can't read the chat as fast as I normally like to. But let's continue. This is an interesting case to me. I think the judge just totally gave him a little bit of a smackdown. Yes. Okay. Also, oh good. The fuck is that noise?
Is the Consumer Protection Enforcement Act portion of the act, which does allow for us to seek actions on behalf of Texas's interest in when there's a public interest. And here we've got a Texas company. So whether they were operating in a regulatory scheme in a different state, they're a Texas company. And if they're a Texas company, then the DTPA applies to them.
No.
All right, Mr. Ringer, did you make notes of my ruling?
I did, Your Honor. Thank you.
Okay, and would you prepare an order and submit it here to the JEA at least by Thursday?
Yes, Your Honor. Thank you.
All right, thank you. You may be excused.
Thank you, Your Honor.
That's this order.
Thank you, Your Honor.
Oh, just for my signature?
What else do we got left? I want to see the end of Judge Pawpaw. Because what happens? 17 minutes? Come on, man. Judge Pawpaw. Yeah, premature
break for that?
agiation.
I can keep going, Judge.
Okay, me too.
All my nexus flexes from Washington to Texas. Texas is place.
All right.
If is interested in an uncontested matter, we have one of those.
And you're next.
Okay.
This is cause number D1GN 23001472. Carlos Maldonado Vinces versus Eldorino Ibarra Uribe Cruz. If you would announce your appearances for the record.
Yes, Your Honor. This is Joe Cortagera for the plaintiff. I don't know why I'm not in.
It's like the cat one. I don't know why I'm a cat.
No, I see you. I see your name.
Yeah, I think I turned the camera to the out the window. Sorry. Let me see if I can fix that.
It's also
Starbucks Double Shot Energy Drink. Focus to do you.
I'm not a window, Your Honor. I swear. What is going on? What has he done? Not the goatee I was expecting.
We see you now, Joe.
Thank you, Lisa. How are you?
Good. Your Honor, Lisa Hintz for the defendant, Ms. Uribe Cruz.
okay. And do we have an attorney ad litem?
Your Honor, Luke Dow, guardian ad litem.
Guardian ad litem. Okay, sir. Thank you.
And my client, Carlos Vences, is also here. Carlos, if you could turn on your camera and your microphone. Great.
Yes, sir. I'm here.
Is anyone else going to testify?
No, I believe it'll just be Mr. Vences.
Okay. Could I ask you to raise your right hand, sir?
Yes, sir.
Do you solemnly swear or affirm the testimony which you may give should be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I swear.
You may lower your hand. Thank you, sir. You may proceed.
Okay. Your Honor, just by way of background, this is a settlement of a case, of a personal injury case of a minor. The child is named Carlos Vences Uribe, and he is currently 16 years old. The settlement is for the policy limits of the third party, and the third party is his driver, his mom at the time. His father brings a case, his next friend of the child, against his mother, and the mother's insurance policy issued by Assurance America Insurance Company has agreed to tender the policy limits, the $30,000 per person limit, and we're here to prove that up.
All right, you may proceed.
Mr. Vences, please tell us your full name.
My name is Carlos Vences Maldonado.
Mr. Vences, you are the biological father of Carlos Vences Uribe, whose date of birth is March 29 of 2007. Is that correct?
Yes, that's correct.
He is your son, and he is the son of Erendira Urida Uribe Cruz.
Yes, yes, sir.
How old is your son today?
He's 16 years old.
Okay. And where does your son live?
He lives in Texas, Kyle, Texas.
Okay. With his mother?
Yes, with his mom.
Okay. But since his mother is the defendant, she cannot act as the next friend.
Yeah, that's correct.
Or you're acting as the next friend of the child, right?
Yes, sir.
Okay.
We understand that this case involves a motor vehicle accident in which there was a failure to yield right-of-way, causing a crash. Is that your understanding of the collision?
Yes, I understand.
Okay. And your son suffered injuries in that crash?
That's correct.
What is your understanding of the injuries that he sustained?
Well, most of nothing he told me about, more like back pain and stuff like that. Yes, sir.
Okay. You know that he went by ambulance to the hospital, he got checked out, had some x-rays done, was then treated with physical therapy at a facility in Austin for many weeks. He had some imaging done, and then he was released from treatment having recovered from the injuries. Is that your understanding of?
Yeah, that is correct.
Okay. You know that we are here because there has been a tentative settlement that requires court approval, and you understand that the total settlement is $30,000.
Yes, sir.
You understand that my law firm will charge fees of $10,000 or 1/3 of the recovery.
Yes, I'm aware of that.
And that we will be paying a combined total of $8,462.91 to 7 medical providers who treated your son as a result of this accident.
Yes, sir.
In addition to that, there are costs of $200. And so the net recovery for your son is $11,337.09. You understand that?
Yes, sir. That's correct.
Wow. Wow, dude. Listen, that goatee doesn't pay for itself.
You understand that that money will be deposited in the registry of the court, and it will not be accessible to you or to Carlos's mother, or even to Carlos until he is over the age of 18 and comes to the court to obtain the funds plus any interest that has been accrued until then.
Yeah, that's correct.
Okay. You understand that you won't be getting any money and Carlos's mother won't be getting any money either.
Yes, I understand.
Okay. You obviously understand also that your son you could, on behalf of your son, choose not to settle the case and instead ask for a trial in front of a judge or jury, where a judge or jury could award more money than the $30,000 or less money than the $30,000 or no money at all.
Yes, sir.
Okay. Knowing all that, are you asking the court to approve the settlement agreement as I've laid it out here today?
Yes, sir. That's what I asked the court for.
Okay. And do you believe that the settlement agreement, as we've discussed it here, is in your son Carlos's best interest?
Yes, sir.
Okay. I'll pass the witness.
Your Honor, the defendant doesn't have any questions.
No questions, Your Honor. He covered everything.
All right, thank you. You may proceed.
Okay. Your Honor, we have a final judgment that we will be filing with the court, or if it has not already been filed. Has it been filed?
It has been filed. It was sent to the 455 submission email this morning.
Okay. And that judgment is signed off by Mr. Dow, Ms. Hint, myself. And so, and it lays out how the money will be dispersed in accord with the settlement agreement and the settlement disbursement that I laid out, including an agreed upon guardian ad litem fee of $1,750, which has also been agreed to by all.
Now that 1750 is not coming out of the 30, correct?
Correct, Your Honor. It's being paid separately to Mr. Dow.
Right. Anything further?
No.
Right, well, I will approve the settlement. I find it is in the best interest of the matter, and it is reasonable. And I may have these numbers not quite right, but they are within the written judgment that there will be $10,000 awarded to the plaintiff's attorney. There will be some medical bills paid at an approximate amount of $8,462.91. And there will be court costs of $200, leaving a net balance to go to the minor in the registry of the court of $11,337.09. Are my numbers correct?
Yes, Your Honor.
All right. And of course, the clerk will be directed to deposit the money in an interest-bearing account, and then it shall be available for release to the minor at the age of majority or thereafter upon proper application to a court. Thank you very much.
Thank you, Your Honor.
Thank you, Your Honor. May we be excused?
Certainly may.
Okay. All right, Carlos.
All right, bye-bye.
You can turn out.
Turn out? What are you, a pimp? You don't turn people out, sir.
Jacqueline, we're all right?
I mean, with that beard, yeah, I guess that's what you think you are, but shit. Turn out. He's like, yeah, fuck, I just made 10 grand. That was so fucking sweet. Oh, I bet. I love making money. I love making money. Oh, not as much as I like watching YouTube, but let's see what else happens here.
Judge, the next case did not request a record, so I'm fine. I can.
Bye-bye.
Hi, Judge.
Let me pull that up.
Judge Papa, bye-bye, honey. I love you too. He's so sweet, you guys. Oh my gosh. Seriously, I've fallen in love with him. He's so on it though compared to some judges that we see. You got to give him that. I've seen way worse stuff being asked and talked about. So, anyways, guys, I love you very much. It's been over 3 hours. I will be back tomorrow with another live. I will be back probably later tonight with some more videos that I'm working on. Don't worry, you're not missing anything. I'm not live. I try and pump out some videos at night before I go to bed and then sleep in a little bit in the morning. But I should get up for the East Coast Court. Anyways, I love you guys so much. I really appreciate it. Make sure you clocked in and out for your shift. Clocking out means you double checked that you hit that like button. And remember that I love you and I'm proud of you. And I'll see you tomorrow. Bye.
Jacqueline, we're all right?
Judge, the next case did not request a record, so I'm fine. I can